Good afternoon, and please be seated, everyone. Thank you for being here. We welcome you to the Idaho Supreme Court for hearing in case number 51211, the Idaho State Athletic Commission versus Office of the Administrative Rules Coordinator. This case is brought by petitioners Idaho State Athletic Commission and the Idaho Division of Occupational and Professional Licenses. That petitioners are represented by Jeffrey Thompson, who will argue, and Meredith Kohler, appearing only today. Respondents in the petition are the Office of the Administrative Rules Coordinator and Brad Hunt. They are represented by Joan Callahan. The interveners in this case, the Idaho State Legislature, are represented by Colby Reddish, and he will be assisted by Mackenzie Lawrence, who appears only. I'd also like to welcome to the bench Judge Stephen Hippler, who will be sitting as pro tem justice in this case due to Justice Stegner's retirement. I believe, counsel, we've had identified that Mr. Reddish will argue first for the interveners, and whatever time, 5 minutes or so, if that's left, will be for the respondent. Other than that, are there any preliminary matters for counsel to raise before we begin?
No, Your Honor.
No, Your Honor.
Very well, Mr. Thompson, please.
Chief Justice Bevin, Justices of the Idaho Supreme Court, Madam Clerk, Counsel, I'm Jeff Thompson, and I do represent the petitioners. The legislature claims that it has powers so broad that it can shut down agency rulemaking completely and can prevent any agency or all agencies from having any enforceable final rules, and it can do so without consequence. Petitioners believe that no branch of the government can exercise its powers, plenary or not, in a way that violates the Constitution. And here, we believe the legislative act of legislative pre-approval, which is the process by which the legislature can review and approve administrative rules before they become final, is unconstitutional for two reasons. It violates the separation of powers doctrine, and it violates the presentment and enactment clauses. And here's the kicker: it does so unnecessarily. It does so because it's unnecessary because there is a constitutionally approved process that gives to the legislature everything that it gets from legislative pre-approval in its review of agency rules. And that process is Article 3, Section 29. Both legislative pre-approval and the post-rule review allowed for under Article 3, Section 29 give the legislature the power to review rules to make sure that they're in conformance with legislative intent. If you do that after the rule is final, then the process cannot shut down agency rulemaking, and it cannot prevent agencies from having final and enforceable rules. Whereas if you have that review like legislative pre-approval has before the rules become effective, then, as has happened in the last 4 years, the process does break down. Agency rulemaking does stop, and agencies are prevented from having final and effective rules. So if we just keep the legislature in its constitutional lane, which is Article 3, Section 29, we can avoid all of the chaos, all of the disarray, all of the extra costs that have been caused by the pre-approval process, which has prevented rulemaking from being final and prevented agencies from having their rules. Now, why does it violate the separation of powers? Why does legislative pre-approval violate the separation of powers? The legislature has plenary power over legislative functions. The legislature does not have plenary power over administrative functions. Once rulemaking is delegated, it becomes an administrative function over which the legislature no longer has plenary power.
So you're suggesting once the legislature delegates a power, it can't pull that power back?
It cannot, unless it goes through the enactment and presentment phase, which is actually repeal the enabling statute. If they want to pull back the rulemaking, if they want control of rulemaking, they cannot do that by inaction or by concurrent resolution. They can only do that by repealing the enabling statute that gave the rulemaking power in the first instance. Once delegated, the legislature has to keep out of that administrative function in a material fashion. It can still be involved, but it cannot materially interfere in that executive function after it's been delegated.
How can it be involved?
Through the Administrative Procedures Act, it does have some involvement in the procedures of rules and rulemaking. But the involvement cannot materially impact or interfere with the rulemaking process. And that's what legislative pre-approval does here. It materially interferes and, in fact, invalidates rulemaking in violation of the separation of powers, which we've shown through the 5 other jurisdictions that have looked at legislative pre-approval and have all determined that, even in the face of the same argument that the legislature is making here, that rulemaking is under its plenary powers, it can do whatever it wants in rulemaking in that situation, and it doesn't trigger a separation of powers violation.
Isn't your argument today the same one that Justice Johnson made in his dissent in Meade, which a majority of this court rejected?
Meade is not opposite, does not apply in this case, Justice Zahn.
But don't the underpinnings of Meade, I understand your argument, I read your brief, you're focusing on the holding, which if I were you, I would do the same thing. The underpinnings of Meade, though, why don't those apply equally to this question, especially when you're making a separation of powers argument?
Because the underpinnings there were focused on a process that looked at rules after they had become effective. In that situation, the Meade court said, that is not a violation of the constitutional separation of powers. Meade did not say that there can be no violations of the separation of powers in the rulemaking arena. In fact, Meade left the door open for just such a legislative act that would interfere with rulemaking. The reason Meade doesn't apply is that reviewing a rule after it has been final does not intrude upon the rulemaking process. The rulemaking process is finished, and therefore any sort of review of a rule after the fact.
Is the rulemaking process prescribed by statute?
It is.
And hasn't the statute been amended over time to allow the legislature to involve itself in that process?
It has been amended to allow the legislature to be involved in the process on
Prior
a
to
post.
final,
Yes, and recently, yes, it has amended to do that.
and Meade indicates, as I understand it, that rulemaking is essentially a delegated authority from a legislative power and not inherently an executive power, that it does. So why can't, what is it about the constitutional amendment, is I think your argument, that would prohibit the statutory scheme currently in effect, or was in effect as of June, end of June 2023?
So Meade was decided before there was legislative pre-approval in any statute.
I understand.
Wasn't even on the radar.
But the concept was that it's a legislative power that the legislature can delegate and can rescind through the statutory process.
And that's the important point here. Yes, it can delegate the power. Once it delegates the power, it's an administrative function.
Didn't it rescind it when it added a requirement that rules, all rules, pending and final, I think, and proposed, are subject to that review?
It didn't rescind the statute. It did not rescind the delegating statute that gave the power for rulemaking in the first instance.
I appreciate that, but it provided a statutory framework for the legislature to have pre-approval.
Correct.
So isn't that the same as, it did it through a different statute? It limited that delegation through a different statute, didn't it?
Again, yes, I think that's the problem. The delegation, the enabling statute that delegates the power to rulemaking here for the State Athletic Commission is 54406.
consistent
They
with
have not
APA?
done any sort of revision, appeal, revoke, repeal of that statute. All they have done is in the procedural acts part of the statutes.
But
added a
isn't
procedure.
the rulemaking granted to it subject to the APA? The rulemaking power is granted to the agency?
No, the rulemaking power is granted to it by 54-406.
I understand, but isn't the power given to it in 54-406 contingent or explained or in some ways limited by the APA?
Unconstitutionally so here, because once you delegate that power under 54-406, you can't add a procedure in the IGAPA statute that then rescinds or revokes or invalidates or repeals that enabling
But they did it
statute.
by the legislative process, through a bill passed by both chambers that went to the governor. The governor, at least at the most recent one, chose not to sign it, but it became law through the appropriate process.
But now what it does is through inaction or by requiring a concurrent resolution, it is repealing the delegation of authority under 54-406 and the myriad other statutes that delegate that authority
That's contingent
without
on-
presenting it, without enacting it, as is required by the presentment
And
and
that's
enactment.
contingent on your interpretation of Article 3, Section 29 as limiting that review to final rules.
Not necessarily, no. I think that there is a separate body of law that says, legislature, you have plenary power to do what you did, to give the enabling statute and to set up the procedures. But once you delegate that plenary power, that legislative power to the agency, it then becomes an executive function. And you cannot then intrude upon that executive function in a way that violates the Constitution. That's what the other jurisdictions say. And frankly, Meade did not change that.
What about the statement in Meade, this conditioned grant of authority is consistent with the principle of separation of powers as set forth in Article 2, Section 1 of the Idaho Constitution, as these acts relate to the executive department? That's on pages 668 and 669 of Meade. How does that statement not say it's a, combine it with the earlier part of Meade, this is a legislative delegation of authority, the latter statement, and legislature, you can condition that on meeting certain requirements.
But only in the context as was decided in Meade, which is reviewing rules after they are final. Nowhere in Meade does it say that legislative pre-approval does not violate constitutional, the doctrine of the separation of powers.
Didn't the people of Idaho, though, weigh in on that issue in 2016 when a majority passed the constitutional amendment that adopted Article 3, Section 29? And there it says that the legislature may review any administrative rule. It doesn't say it has to have been finalized, or it just says any administrative rule. Wouldn't that refer to any period of time then?
No. Rule is not a draft rule or a proposed rule. Rule is a final promulgated rule that they can review any of those final rules.
I don't see final or promulgated anywhere in that article.
Nor do you see temporary draft or pending or proposed rule either. The plain meaning of rule is that it has the power and effect of law. A rule is a final rule, and only a final rule. And if you look at the definition of rule, it does not include draft, proposed, temporary, or pending rules, which are all definitions of what a rule is before it becomes final. So no, Article 3, Section 29 did not give the legislature anything more than the right to review final rules after they've been promulgated.
Except I think the issue with your interpretation, as I read your brief, is you turn to Black's Law Dictionary for that definition. And I'm not sure why you're turning to Black's when at the time the amendment was adopted, Idaho's APA defined 4 different kinds of rule. Final was one. It was not limited to final promulgated. It was adopted by an agency under the regular rulemaking process. So even final rule, as defined in the APA, was subject to compliance with the APA.
I don't think it defined final rule, Justice Long. I think it defined rule as final.
It defines final rule, pending rule, proposed rule, temporary rule. Those were the definitions in the APA in 2016 at the time the amendment was adopted.
My understanding Justice Zahn, is that the definition of rule, without any sort of title in front of it, means final rule. Any other definition, any other type of rule would have to have some sort of a qualifier. Final rule is redundant and superfluous, but when you limit it to rule, then all you're saying is you have the right to review a rule after it is final. And we can look at the definitions that all say rule. When you just use the word rule, they didn't say final rule, they didn't say anything else, they just said rule. That means final. But also, if you look at the floor debate, the constitutional ballot information to find out what was meant by final rule, or by rule rather, it leads you back to Meade versus Arnell.
Except we only need to go there if the language of the amendment is ambiguous.
Correct.
Right? And I'm struggling to understand how the phrase "any rule" is ambiguous. It appears to encompass all rules. In terms of the definition of rule in the APA, it was rule promulgated in accordance with law. And so in accordance with law necessarily implicates the requirements of the APA, doesn't it? I mean, all these roads tie back to the APA, and that's my struggle with your argument when we're trying to define it as a final rule and turn to a definition outside of the APA.
We have reverted to the plain meaning of the word rule, which has been defined throughout dictionaries, other places, as a final rule, not a temporary proposed rule.
Why do we need to go to Black's Law Dictionary, though? Wouldn't the definitions in the APA be the best definitions to apply to this constitutional amendment?
Even if we were to apply that definition to Article 3, Section 29, it still violates the enactment and presentment clause, because what they're doing through the Procedural Act is abrogating the enabling statute.
But wasn't that an argument rejected in Meade? Didn't this court say in Meade, rules are lesser? They are not, they're law, but they are not of the same stature as statutory law. And then it went on to analyze the joint resolution that was used to reject the rules at issue in Meade, and it said that joint resolution does not constitute legislating law, and therefore, because the joint resolution didn't constitute the legislating of law, it wasn't subject to the presentment and bicameralism clauses.
But what Meade didn't say was that some other legislative act, more intrusive than reviewing rules after they're final, would not violate separation of powers. It didn't say that just because it's a lesser power, that it can never be a violation of the constitutional doctrines of separation of powers. It said that in that situation, it wasn't an intrusion enough upon the rulemaking process to be a violation, which makes sense because reviewing a rule after it has been final doesn't impact the rulemaking process at all, because it's already done. Whereas legislative pre-review does impact the rulemaking process in such a way that it completely abrogates the rulemaking powers of the executive.
But it strikes me that your separation of powers argument that you're making would apply to all legislative review of rules. You're saying once they delegate that authority, they can't come back. They're limited. You're making Justice Johnson's argument in the dissent in Meade that you're limited to repealing the Enabling Act or entirely repealing the delegation of rulemaking authority. And so I'm having a hard time taking that argument and saying it applies to pre-approval, it doesn't apply to post-promulgation approval.
I'm only saying that the legislature can't get involved in the rulemaking process. It can't materially invalidate or materially interfere with the rulemaking process. It can get involved in the rulemaking process, and it can get involved in reviewing rules after they're final, as allowed by Article 3, Section 29. It just can't get involved in a manner that completely abrogates the agency's power to rulemake. or keeps the agencies from getting proposed rules. What remedy is available other than keeping the legislature in its proper lane for agencies struggling without rules, for agencies not having, no agencies having any rules? There's a difference between the involvement of the legislature in legislative pre-approval and the involvement in reviewing the rules after the fact. And that difference is the violation of the separation.
I understand your argument, I'm just mulling it over.
The constitutional duty of each branch of our government has been succinctly stated as the legislature makes the law, the executive executes the law, and the judiciary construes the law. Each branch fulfills its constitutional duties in different ways. The legislature enacts statutes. The executive promulgates rules. The judiciary publishes opinions. A material intrusion of any branch into the constitution of the other, even into the mechanism by which it fulfills its constitutional duty, is a violation of the separation of powers.
And so help me understand, we're talking about a statutory delegation of authority in the Commission's Enabling Act. That's not a constitutional power. So how is that a violation of the separation of powers? It's a violation, according to your argument, of the statutorily granted authority, but that doesn't present a separation of powers issue. You've got to have a constitutional grant of authority.
Because once you make that delegation, it moves from the plenary legislative function into the executive function. and
Under
you
what
can't-
provision of our Constitution?
There's no provision of the Constitution. Well, Article 4, Section 20 requires the legislature to delegate the rules, powers, and duties of, to agencies.
Right, it
So
says you have
there-
to allocate them among 20 agencies.
Right.
But nothing in that amendment says, once you delegate an authority, it's now a constitutionally enshrined executive authority.
And it's not that I'm saying that it's constitutionally enshrined. I'm just saying that legislature's plenary power belongs in the legislative functions area. It does not have a place in the executive function area. And once you delegate, then you have to play by the rules, and that is you can't intrude upon the executive branch's authority to execute the law by preventing rulemaking from occurring.
But you said the legislature could entirely rescind that authority.
They could, but they didn't.
And so my point is, to have a separation of powers issue, you have to have two constitutionally granted powers. And what we're talking about is one legislatively delegated authority, and then the legislature's authority to promulgate the laws. And so I'm not seeing where, if the legislative delegation can be rescinded, I'm not seeing how it has constitutional force.
The executive has the constitutional duty to execute the laws, and it does so by promulgating rules. That's a constitutionally enshrined power duty. What the legislature can't do is impede upon that constitutional duty to execute the laws. And that's what it's doing by this statutory delegation of authority that is now trying to take back. Once it delegates, it falls into the executive column. It falls into an executive function. And the executive duty that's being enshrined there is the executive duty to execute the law, which it does by promulgating the rules. That's how I think we get the constitutional.
I understand what you're arguing.
Let's suppose the legislature passes a statute that requires the judiciary to submit all draft opinions for review and approval before they can be published as final. Material intrusion into the judiciary's power to construe the law. The judiciary is not powerless. The legislature is not powerless. It can supersede a published opinion by statute. Now let's suppose the judiciary issues an opinion that says that all draft statutes must be submitted to the judiciary for approval and review before they can be enacted, an intrusion upon the judiciary's power to construe the law. Now, the judiciary is not powerless. It can review a statute after it's been enacted and determine whether it's in conformance with the law. Now, let's assume that the legislature passes a statute that says all agency rules must be reviewed and approved before they become final. It's our position that's an intrusion into the executive's duty to execute the law. But here the legislature is not powerless because it can review that rule after the fact to determine whether it's in conformance with justice, with the law. The legislative pre-approval process has led to chaos, disarray, uncertainty, expenditures of money.
One concern I have with your example is Article 5, Section 13 specifically prevents the legislature from doing to the judiciary what you just described. There is no constitutional provision, is there, that's like Article 5, Section 13, that would prevent the legislature from doing that to the executive branch?
First, Article 5, Section 13 in nowhere enshrines the court's power to publish an opinion without being interfered with.
I suspect a few of us might read that differently.
You may imply that, but there's no wording in that section that says that you have the right to issue your opinions unblemished by anybody else. But in terms of a corollary constitutional power provision, Article 4, Section 20 empowers the agencies with functions and duties to execute the law. It's a constitutional delegation of those powers, functions, and duties.
Your argument, I think, would have more traction with me if there was a similar provision that had language like Article 5, Section 13, which says that shall have no power to deprive the judicial department of any power or jurisdiction which rightly pertains to it as a coordinate department of the government. Constitution, of course, says department instead of branch, but it's the same thing. Is there a commensurate provision that concerns the relationship of the legislature and the executive branch?
I would suggest Article 4, Section 20, which says that the legislature is constitutionally required to delegate the functions and duties and powers to, that an agency needs in order to complete its task of executing the law. That's the corollary that I find here. So the only way to remedy this chaos and disarray that's been caused by legislative pre-approval is to find the legislative pre-approval to be unconstitutional and to issue the writ that we've requested. By doing so, the agency rule-making process can go forward, but the most important thing here is the legislature loses nothing because it can still review every rule for compliance with legislative intent, which is the whole focus of the legislative pre-review. Is it in compliance with legislative intent? It loses absolutely nothing by not having legislative pre-approval by staying with the Article 3, Section 29 process. What it does create is chaos and shuts down agency rulemaking and keeps agencies from having enforceable rules, as we find the State Athletic Commission today. Thank you.
It might be an odd way to run a railroad, but isn't that the legislature's purview to decide how they want that to work?
Not once it's been delegated, Justice Mueller. Once it's been delegated, the only thing they can do is repeal the entire power. They can't delegate it and then take it back by inaction or by concurrent resolution. If they want to have the entire power over rulemaking and they want to do all the rulemaking, they have to repeal the enabling statutes that delegate that power in the first instance. And that requires them then to go pass the bill in both houses. It requires them to present the bill to the governor for signature or veto. And if they don't do that, then what they're doing is repealing and revoking the enabling statutes through inaction or by concurrent resolution, which is a violation of the presentment clause.
Thank you, sir. Mr. Reddich, when you're ready.
Good afternoon, Mr. Chief Justice, Justices of the Court. May it please the Court and Counsel. My name is Colby Reddish with the firm Smith Malik, and I represent the intervener respondent, the Idaho Legislature today. The legislature's position is that the petition should be denied because the petitioners have failed to establish any constitutional basis for their requested remedies, the writ of mandate, and the declaration that what they've termed legislative pre-approval is unconstitutional. It is the petitioner's burden to establish that the changes to the Administrative Procedures Act somehow violate the separation of powers provision of the Constitution. The legislature believes that the petitioners are unable to do so because each of the legal premises on which their arguments rely are contradicted by this court's 1990 decision in Meade v. Arnell. The legislature then requests that this court deny the petition, and this argument is supported by three propositions. The first is that the petitioner's ability to seek temporary rules authorization from the governor's office forecloses their ability to present a justiciable controversy or that a writ of mandate is appropriate. Second is that the similarities between the facts of this case and Meade indicate that there is no violation of the separation of powers here. And third is that Article 3, Section 29 does not act in any way to limit the legislature's ability to review rules in the way that the petitioners allege. I believe when considering the issues presented to the court, it seems clear that if this court finds a violation of the separation of powers in the petitioner's claims, it must first find some implicit constitutional power of the executive to promulgate administrative rules that have the force and effect of law before any form of legislative review. I believe it was Justice Zahn that asked Mr. Thompson, where is the constitutional hook, the explicit constitutional hook for the executive's authority over rulemaking? And he answered that there isn't one.
Well,
So-
hold on. What about Article 4, Section 1? Executive officers listed, term of office, place of residence, duties. They, the executive officers, shall perform such duties as are prescribed by this Constitution and as may be prescribed by law. And so I think that tends to tie into Mr. Thompson's argument that once you say in a statute, Athletic Commission promulgate rules, they have a duty to promulgate rules. So can you respond? That's what I understand his argument to be. You told us to do this and now you're getting in the way.
Yes.
Can you respond to that argument?
I can, Your Honor. I believe that Article 4, Section 1 was considered by the Meade Court. It also looked at Article 4, Section 20. Both of those provisions have very similar language, providing that the legislature may provide such duties as may be provided by law. And this court has specifically rejected arguments in the past from both the Idaho State Tax Commission on very similar constitutional language, that its duties are as have been prescribed by law, that somehow those duties then that arise under statute promulgated pursuant to that constitutional provision somehow have a constitutional hook. And that case is clearly the Union Pacific case from 1982, where the Idaho State Tax Commission argued that the legislature creating the Board of Tax Appeals somehow removed some portion of its constitutional power, and this court squarely rejected that argument. I also believe that this court squarely rejected that argument in Padgett v. Williams when it's looked at, because the Attorney General as an executive officer would be governed under that same provision, Article 4, Section 1. This court rejected that argument that the Idaho Attorney General has any common law constitutional duties that cannot be modified by the legislature. So this court has specifically addressed that argument. And then the legislature's third argument is that Article 3, Section 29 does not act in any way to limit the legislature's ability to review rules in the way that the petitioners allege. If this court were to find some implicit constitutional power of the executive to promulgate administrative rules, this finding would be entirely inconsistent with this court's decision in Meade. Thus, without overruling Meade, it is the legislature's position, at least in part, that this court can find no violation of the separation of powers. I wish to open my comments today, just as the court did in Meade, by quoting from one of my favorite personal Supreme Court of the United States decisions by Justice Jackson in Youngstown Steel. This is one of the most important separation of powers cases in all of American jurisprudence, and it's one of those rare cases where Justice Jackson's concurrence actually controls the legal propositions that come out of it, and it speaks directly to the separation of powers challenges that are sometimes faced between the legislative branch and the executive branch. Justice Jackson stated, and this quote quoted from this concurrence in Meade, stating that there is a tendency that is strong to emphasize transient results upon policy, such as wages or stabilization, and lose sight of the enduring consequences upon the balanced structure of our republic. And it is in light of the enduring constitutional consequences that granting the petitioner's requested relief would present that the legislature's position today is simply to defend its constitutional role under Meade. It is our position that this court cannot find for the petitioners without overruling, at least in part, this decision. As their reply brief cites to Meade's dissent, and as Justice Zahn has asked about, the argument is essentially the same as that which was advanced by Justice Johnson in the dissent, I believe the petitioners seem to recognize this is the effect of their arguments as well.
One of the things that's happened since Meade is Article 3, Section 29.
Yes.
And, you know, the genius of the U.S. Constitution in many ways is its brevity. Because when you start to constitutionalize specific factual situations, you sometimes get protections, but you also enshrine in the Constitution concepts. One of the things Article 3, Section 29 does is enshrine in the Constitution the idea that there is rulemaking by the executive, and it prescribes what the legislature may do in terms of rejecting or approving or modifying those rules. And it permits the legislature to do that through, it doesn't, let me put it this way, doesn't it require some action by the legislature to do that? In other words, can they reject rules by inaction where the Constitution specifically prescribes that they are to either reject or accept, approve, if you will, rules? Doesn't that imply that there's an action by the legislature considering the intent, because it talks about the intent of the rules, to either reject or to accept those rules? And it then goes on to indicate that the governor's got no veto power when they do that, implying, as was explicitly a response to the Meade decision, that there would be some action through concurrent resolution, conceptually, I think, that the legislature would be rejecting with their legislative intent or approving with their legislative intent. So does Section 29, Article 3 require the legislature to actually do something?
Judge Hippler, I'm sorry.
Fine.
I don't need to give you a promotion on the
Well,
spot.
it's not what I asked for.
It's a very interesting question because I've thought long and hard about the role that Article 3, Section 29 plays in this case. Because it has, I think the difficulty answering the question has to do with this court's precedent and how we read the Idaho Constitution. I think if we look specifically to the 2006 Press Club decision, we can see that this court has differentiated between those provisions of the Constitution that enable something that previously was not allowed to happen versus those that act as limitations on the state or the legislature's power. I do not see Article 3, Section 29. Do not see how Article 3, Section 29 can act as any type of limitation on the legislature's power when this court recognized 26 years before its adoption and its ratification by the people that the legislature inherently already had the ability to reserve unto itself the administrative rules review process with the limiting factors that are laid out, the very brief limiting factors that are laid out in Meade. And so I'm not struggling to answer your question, but I'm struggling with the way this court should confront that issue. Because in my view, if we look at the language of Article 3, Section 29, and what would have been offered to the voters, what's a very clear message is that the legislature will have control over the administrative rules review process, at least in some way. It referenced Meade as the petitioners provided in their brief. And so I have a difficulty seeing that as any type of limiting language. To answer your question more specifically about does the language of it require legislative action, I don't read it that way because it always uses permissive language like may. The legislature may do this and may do it pursuant to law. And so I don't read it as a limitation.
But does it condition that language on a review? And I'm going to push back a little and probe a little on your representation that you don't think there's any limitations, because I could see a couple. One is, they may review any administrative rule to ensure it's consistent with the legislative intent. That's why you can review. After that review, the legislature may approve or reject in whole or in part any rule. And this ties back to Judge Hippler's question, which is, when it says after that review, they may reject or approve, doesn't that mean they actually have to conduct a review before they can reject or approve? They can't do it through inaction. They have to actually review it, and this lines up with Meade as well, the latter part of the decision that said, you may have this power, but you didn't exercise it in accordance with the restrictions contained in the statute. How are those not restrictions or limitations or precondition on the exercise of that power?
Yes, Justice Alm, thank you for the correction. I should have been a little bit more careful with my language, perhaps. I don't mean that there are no limitations. I mean that the limitations offered by the petitioners are simply not in Article 3, Section 29. There are some limitations present there. One of the things that I would highlight is that House Bill 206, and this is outlined in our briefing, one of the changes introduced by last year's House Bill 206 is that the legislature will have to act on administrative rules. That is in the, I believe it's in 675291 going forward. They will have to hear administrative rules. And the legislature has been getting ready for that and all that that will entail. And it happens on a rolling basis, I believe on an 8-year cycle that they will have to review administrative rules. So to answer your question, I don't believe any of the limitations in Article 3, Section 29 are implicated by the facts of this case. Both.
Well, let me ask you a
Yes.
little bit more about that, because I read the petitioners to be making a couple of arguments. I mean, one is what I would call the whole enchilada argument. They can't do this at all. But then I see a backup argument, which is even if they do this, they have to do it, they can reject because it doesn't comply or it's not consistent with the legislative intent. And they didn't make that finding here, they just didn't hear it, and it was de facto rejected, and they can't do that under Article 3, Section 29. So would you respond to that second argument that I read in their briefing?
Yes. So the way I would respond to that is similar to the way I answered Judge Hippler's question or began answering Judge Hippler's question, which is I don't see that limitation the same way that the petitioners do.
Don't we
It-
look at constitutional, and I apologize, I shouldn't interrupt you when you're trying to give an answer.
No problem.
When we look at what was intended by a constitutional amendment or a constitutional right or power, the court in the past has indicated that it looks at what was understood at the time. What was understood at the time was that, A, this was a response to Meade, where there was a specific requirement of a finding and a legislative action by both branches, a majority in each, through a concurrent resolution with intent language. And this was also then presented to the people, and that, at the time, was the way in which administrative rules were reviewed. If they weren't reviewed and they weren't rejected, they became final. They became enacted, if you will. They became enforceable. And so that's the backdrop by which Meade, I'll call it the Meade Amendment, was presented, and the people, I think, understood at the time that it was proposed. And that goes to my question about sometimes when you over-legislate in the Constitution, you acquire things that are limitations that you may not have had before.
I can see that point of view, Judge Hippler. I think where I would struggle with adopting that point of view is that this court recognized in Meade that the legislature, had inherent power due to its plenary power over legislation to reserve at least the rejection of rules consistent with legislative intent that is promulgated pursuant to the legislature's authority inherently. And so that's why I've kind of waffled in answering some of your questions is
And the
I do.
legislation at the time, and currently, even in 2022, required, it conditioned in 5291, that the committee would make legislative findings, and that then the legislature would approve or reject the rules based upon consideration of those findings. And so it's not just the Constitution that implied or expected action, it was also the legislation.
It is, and I think that's one of the unique things about this case, is that the petitioner's alleged injury essentially arose under the previous statutory scheme, yet they're using that injury to, at least in some parts of their briefing in the petition as I read it, to challenge the new legislative scheme. And so the legislature's position is that the new legislative scheme, which is in effect, that it is entirely consistent with any of the limitations that Justice Zahn has asked about in Article 3, Section 29, and that it's also consistent with this court's decision in Meade.
But as to the writ and what happened with the I'll call them the 2022 rules that were rejected through inaction, you have the inherent power recognized in Meade, but then you have a subsequent constitutional amendment that appears to condition the exercise of that power to a certain extent. You can approve or reject after you review the rules to determine whether they're consistent with legislative intent. And where the review to determine if they're consistent never occurs, how do you trigger the authority to approve or reject? I mean, that's where I'm looking at Meade, and I'm saying it's been subsequently changed to a certain extent by the adoption of Article 3, Section 29, which, puts some limits on the legislature's authority to review.
Justice Zahn, it may put some limits on the legislature's ability to review some of the ones that we've discussed. I simply don't see how they are implicated by the petitioner's challenge.
Well, their challenge, the backup challenge, as I'll call it, is you didn't perform any review, and you can't accept or reject until you perform a review. How does Article 3, Section 29 not direct that? To accept or reject, you first have to review.
And I think that's where I would look specifically to the remedy sought. If the alleged injury was the legislature's inaction, I believe the remedy sought probably should have implicated the legislature. If that was the petitioner's challenge, the legislature is here as intervener. And so I struggle to see how it would be proper to recognize the legislative inaction that wasn't directly raised in the petition, I think, in the way it should have been by the remedy sought.
But the writ seeks publication of the rules, and the person who's responsible for publishing the rules in the code is the person against whom the writ is sought. The legislature doesn't have the authority to publish the rules. So I'm struggling. Help me understand. What am I missing on your remedy argument?
Well, I believe I didn't articulate my answer very well. That's probably why you're struggling. I believe one of the reasons that the remedy would have had to have been different is if the legislature was failing. A writ of mandate is proper when some government actor is failing a non-discretionary ministerial duty. And so if the petitioner's argument is that the legislature somehow failed by not hearing their rules, I believe that should have been addressed in a writ of mandate directed to the legislature directly.
Well, that goes to my issue then. Is the term review as used in Article 3, Section 29 a term of art that means something in particular? What does it mean that the legislature must review it? Does it mean they have to take it to a vote? Perhaps I think Mr. Thompson would think so. Or does it mean it have to be assigned to the germane committee so that they can review it? Does it mean they have to have a hearing? Or does it just mean they all have to read it and say, nah, we're not going to do anything? What does legislative review mean when it comes to a administrative rule?
Right, and that is one of the inherent difficulties in answering that question, Justice Mueller. I believe that's why my argument is focused on the language of the IDAPA today after the amendments of House Bill 206, because it does require hearings in the germane committees.
What did it mean when the Constitution was amended?
That is I think that's one of the
Isn't that
difficulties.
we have to decide what at the time the Constitution, that amendment was put into effect, what did the term review mean?
Well, I don't have a strict definition from the IDAPA at that time that I can offer the court, but I believe that the term review is incredibly broad. And one of the things that this court's both constitutional and statutory interpretation jurisprudence focuses on is that words are to be given their plain, obvious, and ordinary meaning. And legislative review can incorporate a number of different things. Again, I believe the legislature's position today is to defend House Bill 206, not necessarily the past legislative inaction. I don't believe that the past legislative inaction, as the petitioners have raised it, is properly in front of this court.
Is legislative review not somewhat like judicial review? Judicial review requires us to typically make a decision.
Right. I can see that perspective, Justice Mueller, and I think that's where it really just comes down to back to this court's decision in Meade and whether the legislature, how broad the power the legislature has to reserve unto itself through statute what it means to review, what it means to define what review means. Obviously, I think the
Meade
position
required findings of fact, at a minimum.
under Meade, yes, it does, absolutely, and under the language of Article 3, Section 29.
And then we have to look at what does it mean to accept or reject. Reject being a word, it's a active word. And it seems to me there's an argument, particularly understanding the times at Meade as well as in 2016, that the way that these rules were rejected and the way it's conceptualized in the constitutional amendment is through a concurrent resolution, not through somebody putting it in a desk drawer and saying we're not going to look at it.
Right. And I do believe the changes introduced by House Bill 206 are entirely consistent with this court's decision in Meade and those limitations. Judge Hitler.
I think that's interesting because unlike the federal government, we basically have a pocket veto in Idaho that works just the opposite way, right? If the governor doesn't sign something, it becomes law. Here, if the legislature doesn't act on something, it doesn't become law. It seems like an interesting difference in approach.
It is, but it's not unprecedented. Even if we look to Meade itself, one of the things I was surprised by to see in petitioner's reply brief was a favorable cite to INS v. Chadha, because in this court's decision in Meade, it specifically quotes extensively from Chadha's dissent and specifically highlights the fact that the constitutional language in the federal constitution that required the SCOTUS majority's opinion in Chadha did not control in Idaho. And so it's not irregular, I believe, Justice Mueller, for the Idaho Constitution to be interpreted differently than the federal Constitution, even sometimes on very similar language. As this court is well aware, and this isn't a criminal case, but as this court is well aware, Article 1, Section 17 has been interpreted to have a different scope than the federal Fourth Amendment. And so I don't view that as at all irregular constitutional interpretation.
But Article 3, Section 29 is couched in terms of may.
Yes.
So the legislature may review any administrative rule, and they may approve or reject. So when you indicate that a writ of mandate should be directed to the legislature, how could you possibly do that with may language? I mean, it's got to be a ministerial duty.
Right, Justice Brody. I believe in that case I was answering a question specifically about the previous version of IDAPA. So I view the language of the Constitution to purely be permissive. I understand that there are different opinions on that, but I believe the writ of mandate would have been addressed to cure the alleged defect in the legislature not hearing rules under the previous version of IDAPA, if that was a requirement.
I'm struggling with that argument. Because again, with the permissive language of the constitutional amendment, I don't know how you compel them to review it. At the same time, I'll tell you, help me understand why you think the writ of mandamus claim is controlled by the current law when the actions occurred under the old law. Because when I think about the writ of mandamus request, I think that's entirely controlled by the pre-July 1, 2023 structure.
Yes, I can understand that, Justice Ahn. Can you restate your question for me?
Well, you made a statement that you think our analysis is controlled by House Bill, I've lost it, 206, 208. I'm conflating my 6s and 8s. At any rate, but the writ of mandamus claim is all about the failure to publish the 2022 rules. The failure to publish the 2022 rules is premised on the pre-House Bill 206 regime. And so how do we analyze that claim under anything other than the pre-House Bill 206 set of statutes, which allowed rules to be rejected through inaction?
Yes, so I believe that's where, if we look at the two claims that the petitioners have essentially advanced, and I think this has been one of my difficulties in wrapping my head around this case, is they are incredibly intertwined, because the language of Article 3, Section 29, as we've been discussing, is wrapped up in Meade. And Meade is wrapped up in their separation of powers challenge. And so that is the difficulty that I'm struggling with, is how to unravel all of these things. It seems to me that if this court were, it seems to me that this court would need to find a separation of powers violation to ground the writ of mandate. And so that is why I keep turning back to Meade and the language in Article 3, Section 29.
See, and I'm focused more so on their argument that the pre-House Bill 206 regime violated Article 3, Section 29, because it allowed rejection of rules through inaction, when Article 3, Section 29 said you can only reject after reviewing to determine whether it's consistent with legislative intent.
Right, and that the legislative inaction then grounds the writ of mandate. And I think that's where I just do not know, I cannot think of another case where legislative inaction that's brought against some third party would ground a writ of mandate. I believe the writ of mandate should have been sought to require the legislature to sit and hear the rules.
Even though the constitutional amendment says you may review, and then essentially, if you choose to review, this is how you can approve or reject. It's after you review it to determine if it's consistent with legislative intent.
I do believe that, because if the violation was of the statute, that would be the allegation, and the constitutional provision would obviously have some relevance, but its permissive nature, I don't think, the legislature still has to follow statutes that it passes, and that's where I think that analysis would hinge on.
Even if the statute allowed it to be rejected through inaction.
I believe so. If I can briefly read, I think, one important paragraph from this court's decision in Meade. This court highlighted that, of course, in Meade, this court heard the challenge very similar to those raised by the petitioners, and this court stated explicitly that legislative inaction has not invalidated the executive department's execution of law. So turning back to your questions earlier, Justice On, about Article 4, Section 1, Article 4, Section 20, this argument has been flatly rejected by this court. Such would be the case, for instance, if the legislature had passed a concurrent resolution to prevent the Attorney General from taking legal action for some violation of a statute. Enforcing the law of this state is a constitutionally mandated executive department function resting in the office of the Attorney General. In such a case, no delegation would be involved. Conversely, in this case, the board's rulemaking power comes from a legislative delegation. Rulemaking that comes from a legislative delegation of power is neither the legal nor functional equivalent of constitutional power. It is not constitutionally mandated. Rather, it comes to the executive department through delegation from the legislature. This court, as noted, has consistently found the executive rulemaking authority to be rooted in a legislative delegation, not a power constitutionally granted to the executive. And the legislature's position today is simply that this court's already decided many of the legal premises upon which the petitioner's case relies. We would ask that this court deny the petition.
Just one quick question. You cited this language in your brief from the Union Pacific case,
Yes.
which was quite a few years ago, where we said that when the people of our state have deemed it necessary to impose specific duties on constitutional entities, they have done so in a manner which is clear, and our Constitution contains many such examples. Would this be one of those examples? Article 3, Section 29?
I don't believe so, Justice Mueller. And the reason I don't believe so is, as we look at that decision and we look at the Press Club decision, we have to look for very specific use of limiting language. And all of the language in Article 3, Section 29, from my review, is permissive and allows the legislature to continue to reserve unto itself the powers that this court decided it already had in Meade.
Any other questions? Thank you, sir.
Thank you.
Is there any time remaining for the respondent?
Sorry, Joan.
1 minute and 1 minute and 40 seconds. Is that correct, Madam Clerk?
Chief Justice and Associate and Pro Tem Justices, may it please the Court. My name is Joan Callahan with the law firm of Naylor and Hales, and I represent the Office of the Administrative Rules Coordinator and Brad Hunt, the Rules Coordinator. My points today for argument were regarding this court's original jurisdiction in this matter and the urgent necessity for you to decide the constitutional issues. Given the robust discussion with my other parties today, it doesn't seem that those points are necessarily of concern for the court. And knowing that I have a minute, I would just stand for any questions that you would have.
Appears we don't have any.
Thank you.
Thank you. That, Madam Clerk, how much time is left for the petitioners? 2 minutes, sir.
Very quickly, Justice Zahn, I'm worried that we're going into Article 3, Section 29 in a way that somehow says that that provision allows the legislature to review rules before they've been final. The Constitution says final. It does not say, the Constitution says rule. It does not say final rule. Yes, final rule is defined in that version of the statute as one that's in full force and effect. But the word rule, which is what's in the constitutional amendment, is defined as a final rule, is a rule with full force and effect. So the use of the word rule, rather than using the word final rule, means that they were only focused on or they're only allowed to review rules that have the force and effect of law, final rules. They did not use the other terms for rule, proposed, pending, or whatnot. As to Meade, this court has not actually ruled on whether legislative pre-approval is, in fact, constitutional. It has not ever been faced with that issue. Other jurisdictions that have been faced with that issue have found that it is a violation of the Constitution, even in the face of the argument that it comes from the plenary powers of the legislature.
They found it was inconsistent with their own state constitution, right?
Which in almost all important respects, is the same as Idaho's constitution.
Do those other states have something with the same language as Article 3, Section 29?
No, they don't have that. What I'm saying is that, because Article 3, Section 29 only talks about rules after they're final. We're talking about legislative pre-approval here. Meade does not stand for the proposition that legislative pre-approval or involvement of the legislature in the executive prior to the rule becoming final is not a violation of the doctrine of separation of powers. I see my time is up. Thank you.
Thank you very much, sir. Counsel, to each of you, thank you for your efforts in this case and the good discussion we've had with the court today. This matter is now under advisement. We will render a decision accordingly, and we will be in recess until Monday.